Okay, so a very good afternoon to everybody who has joined us today for this session. The topic of discussion of the day is the constitutionality of tribunals in India, a critical analysis with reference to Tribunal Reforms Ordinance 2021. So for discussing this topic, we have with us today Mr. Abhinav Shukla, and he has done his BLLB honors from Hidyatullah National Law University, Raipur, and his master's in constitutional law and GST laws from OP Jindal Global University, Delhi, NCR. He is presently pursuing his PhD in advanced constitutional laws. Previously, he was working as the head office of at the head office of Career Launcher, Delhi, handling the All India Law Preparation Division as national anchor of LST. Earlier, he has also worked as faculty and mentor at IMS head office, Mumbai, and Career Launcher, Raipur for 3 years. Presently, he is working as an assistant professor of law at Amity Law School, Amity University, Chhattisgarh, since last 2.5 years. He prefers to be with the students to mentor them and rather to be in the courts. He also writes columns for National Daily, The Daily Guardian, New Delhi, The Hitwara, and the other newspapers, and blogs on contemporary social legal issues. I feel really privileged to have you here for the session, sir.
Thank you.
So let's go forward with the session. So the very first question that I would like to ask you is that what is the constitutional basis for the establishment of these tribunals?
Okay. So when we talk about the constitutional basis, the powers with regards to the establishment of tribunals and courts in India. So the parliaments and the state legislatures in India have got the powers with regards to the establishment of tribunals and courts in India. When we talk about the tribunals, they are the quasi judicial bodies which perform adjudicatory functions, but they are a bit different from the courts in the sense of their composition, in the sense of their functioning. We'll be seeing into it with regards to how the difference is. When we talk about the establishment aspect, so the parliament and the state legislatures, they get these powers specifically through few of the statutes, okay, and generally through Article 323A of the Constitution and Article 323B of the Constitution of India. Now, these two provisions were added through the 42nd Constitutional Amendment Act. So the powers, the constitutional authority to establish tribunals that is being given to the parliament and to the state legislatures, they come through these provisions of the Constitution generally and specifically through some statutes. Like, for example, if we talk about the Film Certification Tribunal, so it is through the Cinematographic Act. If we talk about the Intellectual Property Board, so it is through the Patents Act, and so on. Now, these when we talk about the constitutionality of these, or the constitutional basis of the formation of these tribunals, so there have been few landmark cases where the very constitutionality of these tribunals were challenged in the Supreme Court of India and also at various high courts. So one specific case with regards to Article 323A and 323B. Yes, also to mention why these two different provisions are there. So 323A is with regards to the establishment of administrative tribunals in India, such as we have the central administrative tribunals, etc. And 323B is specifically with regards to the establishment of the tribunals for other matters, such as for the taxation matters, for the matters of industrial disputes, and so on. So in the case of L. Chandra Kumar versus Union of India in 1995, the constitutionality of establishment of tribunals was challenged in the Supreme Court on various grounds. Few of the grounds, if we look into, so it was about the exclusion of jurisdiction of Supreme Court and High Courts. Because when we look into the establishment of tribunals, the power of the parliament and the state legislatures to establish the tribunals, they also get the power to exclude the jurisdiction of other courts. Okay, So, and in that regard, also the exclusion of the jurisdiction of High Court and Supreme Court. So these were few questions that were brought in front of the Supreme Court in the case of L. Chandra Kumar, that, whether the establishment of the tribunals is constitutionally valid. If we talk about the constitutional basis, to what extent they can exclude the jurisdictions of the highest, the apex court of India, or the other constitutional courts. So in this regard, the Supreme Court in L. Chandra Kumar said that the jurisdiction of the high courts and supreme courts under the high courts and the Supreme Court under Article 226 and Article 32 respectively, which are the writ jurisdictions of the Supreme Court and High Court, this can never ever be excluded, because this has been considered termed as a part of the basic structure of the Constitution of India as propounded in the Keshwaran Bharati case. So these two provisions, so approaching the high courts and the Supreme Court against the decision of any tribunals or against the decision of any appellate tribunals with this regard, they can never be excluded. And also Article 136, the jurisdiction of the Supreme Court with regards to the special leave petition, this also can never be excluded, although this is mostly mentioned in all the provisions. In fact, Article 323 and 323b as well, when we talk about the jurisdictions of the Supreme Court. Jurisdiction of the tribunals. So the tribunals have been held to be constitutionally valid. It's not that the tribunals, have been declared by the High Court and Supreme Court that they cannot be established, or how can they function as a substitute of other courts. In fact, there is a wonderful comment given by the Supreme Court with regards to tribunals. It said that the various tribunals, and especially when we talk about the tribunals at par with or kept on the same foot of the high courts, it is the appellate tribunals, which we are going to talk about largely under the present ordinance. So the appellate tribunals, they function as kind of a replacement of the High Court. So in this regard, the Supreme Court said that the various tribunals, they are not the substitutes of the High Court, where rather they are the supplement. They can function, or they function as the supplement to the High Court. So this is about the powers of the Parliament and the state legislatures to establish various tribunals, and the constitutionality of these tribunals, which has been restored, which has been held valid by the courts in various cases. And with regards to the exclusion of jurisdiction of Supreme Court and High Courts, this has been the legal development till date. You're not audible. You are not audible, Mani. You are muted and you're not audible. You are in mute and you are not audible.
So the next question that we would like you to address is the tribunals as quasi judicial bodies, the powers, the functions, and how are they different from constitutional courts or the ordinary courts?
Right. So as you also mentioned, that the tribunals function as, or they are termed as, quasi judicial bodies. They are not considered as judicial bodies or the traditional courts that we call in India. So if we talk about the Indian judicial system, we have a hierarchy of the traditional courts in India. We have the Supreme Court, we have the High Courts, we have the district courts, the subordinate judiciary. Other than this, there are various quasi judicial bodies in India, and the tribunals are one of those quasi judicial bodies. Now, why are they said, or why are they called quasi judicial, or on what aspects they are different from the other constitutional courts or the subordinate judiciary? First difference is with regards to the composition of the benches or the composition of the members of the judiciary. While in the judiciary, we have the judges, in the subordinate judiciary, we have judges at different hierarchies. We have the judicial magistrates, we have the district session judges, and then at the high courts, we have the high court judges. At the Supreme Court, we have the Supreme Court judges specifically to preside over the courts. Whereas when we talk about the tribunals, It consists of various members. It consists of chairpersons. It consists of members. The composition differs from tribunal to tribunal. The members and chairpersons are appointed by a selection committee, which consists of, the members from judiciary as well as from the executive. And one specific thing to be noted over here with regards to difference between the traditional courts and the tribunals is tribunals also consist of non-judicial members, which means it consists of chairpersons or members who are retired judges. That is, they are considered to be judicial members, or maybe members, judges on deputation coming and serving in the tribunals. But the tribunals also have technical experts. They also have non-judicial members. So the people who are not judges from their background, from the professional background, they are also a part of the tribunals. This is one significant difference between the tribunals and the courts. Then the second difference is with regards to the functioning. While the traditional courts, the Supreme Court, High Courts are very much bound by the procedural laws that we have, the tribunals, with regards to the functioning of tribunals, they are very much bound to act in accordance with the principles of natural justice. But with regards to some of the procedural, not going into the very technical context, but there are differences. And the tribunals, they function on certain aspects where the procedural aspects are relaxed to some extent. So this is again one of the difference between the functioning of the tribunals and the other courts. Now, one major technical difference is with regards to the jurisdiction. While if we talk about the civil courts in India, they are allowed to take all the civil matters as far as they are not excluded or not restricted specifically under the CPC or other provisions. Whereas the tribunals are specific, subject related or specific law related quasi judicial bodies. So they are not allowed to take any matters. They are allowed to take matters related only related to their technical fields. So this again is one of the differences. Whereas the Supreme Court, High Court, the civil courts, or the criminal courts, the Sessions Court, they are open to all sort of cases or matters. It's not specifically restricted to some extent. So these are few differences due to which the tribunals are termed as quasi judicial bodies, whereas the other courts are, they are considered to be the full courts or traditional courts. And this is how the functioning, the composition, the overall aspects of the tribunals, they differ from the other courts.
That was really insightful, sir. Coming to the further topic of discussion, I would really like you to enlighten us upon the Tribunal Ordinance Reforms Ordinance 2021. So what are these reforms and what changes have they brought into?
Okay, so while we are discussing about, or we have to discuss about the Tribunal Ordinance, Tribunal Reforms Ordinance 2021, which has been very recently, brought by the Government of India, has been given by the President of India in 2021. We need to look a bit or go back a bit about the background of how have we reached over here. So in accordance with few of the amendments or changes brought, in the powers of the Government of India, the Finance Act of 2017 empowers the Government of India to make rules with regards to the tribunals in India, which includes the appointment of members, the terms and conditions of the members and chairpersons of the tribunals, the functioning of the tribunals, and certain other aspects of the tribunals, which may also include the abolition of tribunals, as I said, the terms and conditions of the service of tribunals, the members, etc. In accordance with this, in 2017, the Government of India notified tribunal rules with few aspects, such as the changes to be brought with respect to the appointment of the members of the tribunals, with respect to the service conditions. But this was challenged at the Supreme Court of India in the case of Roger Matthew versus South Indian Bank Limited. And in this particular case, in 2017, Supreme Court had struck down all those rules notified by the Government of India, with regards to the tribunals, with regards to the appointment, service conditions, matters, etc. And the major aspect, or when we look into the judgment, the Roger Matthews judgment of the Supreme Court, so we see that a significant part of the judgment was with regards to a question on the judicial independence, because some of the changes, few of the changes, not going into the very specific rules and notifications, because we'll be more in detail talking about the present ordinance. So in that 2017 rules, the government of India had given kind of a primacy or supremacy to the executive on the appointment of the members and chairpersons of the judiciary. So there was a question on the judicial independence, which was considered by the Supreme Court, and in the judgment also the Supreme Court has specifically mentioned that the 2017 rules, they to some extent compromise with the judicial independence. So therefore the 2017 rules were struck down by the Supreme Court, and the government of India was asked to notify, or to frame other rules and other rules and regulations. In this context, the government of India again notified new rules and regulations in February 2020, which can be termed as an old wine in a new bottle, because a lot of changes, or a lot of the major reasons due to which the Supreme Court had struck down the 2017 rules and regulations, or the notification, those were brought as it is, or to a great extent, in the 2020 notification as well. So this was again challenged in the case of Madras Bar Association versus Union of India in November 2020, wherein the Supreme Court had again taken a note of the 2020 rules and regulations issued by the government of India with regards to the tribunals. So in this particular case, the Supreme Court gave certain specific guidelines to be followed by the government of India while framing rules and regulations with reference to the tribunals. So the specific guidelines given by the Supreme Court of India consists of, the term of office. The term of office should be minimum 5 years or 7 years. Then the judicial members, or the judges who will be a part of the selection committee, what should be that in number, so that a primacy should be given to the judiciary, or at least the judiciary should have an equal say while the appointment of members and the chairpersons of the tribunals. Also, few other suggestions given by, one of the significant suggestions given by the Supreme Court in this regard was establishment of a National Tribunals Commission. Okay, that is still pending. So National Tribunals Commission, the Supreme Court suggested that there should be a commission which will keep an overall supervision on the service, terms and conditions, office of all the tribunals over India. Okay, so that we can have one specific dedicated body consisting of judicial members, non-judicial members, keeping an overall supervision, not supervision with regards to judicial functioning, but mostly with regards to the terms of office, etc. So these were few suggestions and guidelines issued by the Supreme Court, on the basis of which this present ordinance has been issued by the President of India in 2021. Now, as we know that, ordinance under Article 123 of the Constitution of India, the President may issue an ordinance. Ordinance is just like an ordinary legislation. So ordinance is to be issued when the President is satisfied that there exists a situation of great emergency, or such urgency that the Parliament is not in session, and further it cannot, the government cannot wait for the Parliament to come in session. So therefore, ordinance is issued in such matters. In accordance with that, in February 2021, very recently, the government of India brought this particular ordinance, which was notified in April 2021. Now, what are the issues in the present ordinance of 2021, and whether it is in consonance with the Supreme Court's judgment in Madras Bar Association of 2020, or the guidelines issued by the Supreme Court, or it is in conflict with them? So when we talk about the issues, the first very issue is wherein the government of India has blatantly overlooked the guideline or suggestion given by the Supreme Court, that is with regards to the term of office. So this ordinance of 2021 had fixed the term of office of the chairpersons as 4 years or 70 years of age, whichever is earlier, and for the members as 67 years and 4 years of tenure, whichever is earlier. Okay, so in both the cases, for chairperson 70 years of age, in case of members 67 years of age, and the tenure 4 years for both of them. In this regard, the Supreme Court had specifically said in Madras Bar Association case that the tenure should not be less than 5 years. It should be minimum 5 years or 7 years. The reasons the Supreme Court gave in this regard is, once a person becomes a member of any tribunal, or the chairperson of the tribunal, it takes him time to get into the particular technical aspects, the procedural aspects of the particular tribunal, the expert body. And once the person starts functioning very efficiently, if you remove the person or retire the person within 3 to 4 years, then it is not going to help out with the judicial functioning or with regards to the efficiency of the justice delivery system. So, because, for example, let's say somebody has been appointed, a retired Supreme Court judge is appointed as a chairperson of a tribunal. So he'll be appointed, or as a member, he'll be appointed at the age of 65 years or 66 years, because the retirement age of Supreme Court itself is 65. And if the person is a member, he'll retire within 1 year. And if a person, even if he's made the chairperson, he'll retire within 3 to 4 years. So this is something which the government of India has overlooked and has completely, ignored as a suggestion which was given by the Supreme Court. With regards to the selection committee, the government of India has very well adopted and has very well put those changes, has very well inserted these changes in the new ordinance, wherein the Supreme Court's concern was that the judiciary must have an equal say with regards to the appointment of the members and the chairpersons of the tribunal, because ultimately it is about, what are the tribunals doing? They are to some extent working as an alternate of the courts, of the trial courts, of the appellate courts. So the members of the judiciary, the judges, the chief justice, the other judges, they must have an equal say with regards to appointment in the selection committee. Also, the government of India is the biggest litigator or a party in most of the litigation matters, whether even in case of tribunals. So the executive, who is in itself a party in most of the cases, is also responsible for appointment of the members of the chairpersons. So if the executive has a primary say over the judiciary says, then it is, violation of the principles. So in this context, the Supreme Court's concern was judiciary must have at least an equal say. So this has been very much considered by the government of India. Then one particular context, National Tribunals Commission suggestion, which I told you, which the Supreme Court said this has not been adopted yet. This is still pending. But this is something which I personally also consider that, yes, there should be one particular such commission which to keep an overall supervision with regards to at least the service or terms of office of the members of the tribunals. Then, okay, now talking about, yes, also one particular aspect is what change this particular tribunal has brought. So first, it has abolished 9 appellate tribunals in India. So 9 different appellate tribunals, or rather to say different appellate tribunals which were functioning, which were established under various 9 different statutes in India, they have been abolished, and their powers have been transferred, their functions have been transferred to the concerned high courts. So now what would happen? Now the matter would first go to the particular tribunal at the trial stage. Let's say, for example, let's talk about the Film Certification Appellate Tribunal, FCA, which was established as an appellate tribunal under the Cinematographic Act of 1952. So under this particular act, the matters related to film certification in India is with the CBFC, the Central Film Certification Board, which we informally call the Censor Board of India. So the Censor Board or the CBFC has the authority with regards to deciding, whether the movie can be released or not, with how many cuts, with A certification or U certification, or it cannot be allowed to release at all, whatever it is. The appeal with regards to CBFC was going to the FCA, Film Certification Appellate Tribunal. Now, since the FCAT has been abolished, now the appeal would lie to the High Court instead of FCA. Similarly, the other tribunals which have been abolished, Intellectual Property Appellate Board is one of a very significant board which has been a very significant appellate tribunal, which has been abolished. This was in place with regards to, and for this, various acts which have been amended: the Patents Act, the Copyright Acts, the GI Act, the Plant Varieties Act, etc. Then the Airports Authority Appellate Tribunal, this also has been abolished, which used to work as an appellate authority for both Airports Authority as well as the National Highways. This has also been abolished. Then we do have, there was this advance, authority on advance ruling under the Customs Act. This has now been abolished and the authority has been transferred to High Courts. So these are various technical changes with regards to the structural changes that has been brought by the Ordinance of 2021, the Tribunal Reforms Ordinance of 2021. Now, what impact is it going to have, and what has been the primary reason to bring this particular reform is, or what was the need to abolish these appellate tribunals? So if we read into the objectives of the particular ordinance, so the objectives specify that, this would establish more judicial independence. This is likely to establish more, because obviously the functioning of high courts, and in this regard, when we say, so the procedural aspect, or in that context, or with regards to judicial independence especially, it is going to be more judicially independent. But a major concern or issue for the judiciary or for the high courts is the burden of cases, because we already are aware of the fact that the high courts, the Supreme Courts, the subordinate judiciary is already so much overburdened. And now these appellate tribunal matters are going to come to the high courts, and the high courts will have to look into the question of facts and all these things, as an appellate, because it's not working as a review body or as a writ court. It is going to work as an appellate tribunal. So the burden is going to increase, obviously. So this is also a concern which has been shown by a lot of legal experts in regards to this. Also, one specific example which I remember from one of the contemporary social media developments, etc. Few people from the film industries, to name few directors or few producers, they are very much disappointed with the government's decision to bring this particular ordinance with regards to abolition of the film certificate appellate tribunal. And the reasons given by them is, the high courts are not going to take the release of a movie as an urgent matter. So they have this particular doubt or risk in mind that it is likely to increase the pendency of the matters. It is likely to increase, the duration of the hearings, and it is likely to delay the release of movies. And, we all know that the movies are made with regards to certain contemporary or context in some of the other context. And if it is supposed to release in this year and it is going to release after 6 months or after 1 year, then the impact of the movie or a lot of negative impacts can be there. So why the FCAT's authority has been transferred to high courts is a major concern for the film producers, film directors. There is an example also which was cited by, I'm not remembering the name of the director. There was a movie called Lipstick Under My Boka. So this movie was completely said to be was not allowed to be released by the the CBFC, Central Board of Film Certification, that is the censor board. But when the matter went to the appellate tribunal, that is the FCAT looked into the matter. That the FCAT said that no, this movie can very much be released with an A certificate, and with few cuts, the movie was allowed to be released, and this happened within a span of very less time. So the filmmakers are, doubting that these kind of scenarios are maybe not likely to happen when the matter will be with the high courts. So these are few concerns, issues with regards to, and the reforms and the changes that have been brought by the Tribunals Reforms Ordinance of 2021.
Coming back to the last issue of the topic of the session, we need to understand that what is the need of these tribunals, sir? What are the pros of having them and the cons of not having them, and what impact are these tribunals having on the Indian justice delivery system?
Okay. So when we talk about the need of establishment of the tribunals, why at the first place the tribunals are needed when we already have the judiciary, we already have the well-established judiciary at the different levels, at the hierarchies. We have a unified judiciary, we have independent judiciary, and we very much have proper organizational structure of the judiciary in India. Then why do we need the tribunals? So one reason, or this question, this also takes us to the particular question that why through the 42nd Constitutional Amendment Act, Article 323A and 323B were inserted in the Constitution. What was the need? When the Constitution makers did not think of providing any provision for tribunals, then why was the need? So one of the reasons is the technicalities. As the recent example I gave of FC80, the filmmakers are now worried that when the matters would be heard, the matter would be heard by the high courts as appellate tribunal. Maybe it's not that we are questioning the competency of the traditional courts. It's not that we are at all questioning the competency of the traditional courts, the high courts, the Supreme Court, or the magistrates. But the technical aspect is something which actually works to a great extent. Let's take for an example, let's talk about the Competition Commission of India, the CCI, which has been established through the Competition Act lately in the this particular new century. So the CCI consists of judicial members, non-judicial members, the technical experts. Similarly, we have other tribunals. So when these tribunals work, they look into the technical legal aspects of a particular matter, which is very much required when dealing with the matters, when dealing with the cases. And it is specifically dedicated to a particular legislation, dedicated to a particular law, okay, which can similarly not expected from the traditional courts. The reason being, they are already overburdened, and they are, it's not, we cannot expect all the magistrates or judges to be experts of competition matter or film certification or taxation or industrial tribunal or administrative matters, etc. So technicality or technical expertise is a very sound reason for the establishment of tribunals or the appellate tribunals in India. Okay. Then the second reason being the already overburdening of the courts in India. The courts are already overburdened with the matters. If we look into the overall number, we know that more than 3 crore pending cases are there in India. So through the formation of the tribunals, it is also considered to be one of the methods or one of the ways of transferring the matters to the other tribunals. Those tribunals will be working as additional courts, additional quasi judicial bodies. So the burden would be shifted to some extent at least. So these are few reasons why the tribunals are established in India, and why the power is given to the parliament or the state legislatures to establish tribunals or appellate tribunals in India. Now, when we look onto the cons, what are the cons of the tribunals being established in India? So the cons can be, as the recent reforms on 2021, this has cited why the appellate tribunals have been suddenly abolished and the powers have been transferred to the high courts. So judicial independence is something which can be considered as a con, because again, because this was also a issue or concern raised by the Supreme Court in the Madras Bar Association case of 2020, that executive or the government, they are litigators, they are party to litigation, and they are also having an equal say or a primary say over the appointments of the members and chairpersons. So the question on judicial independence is likely to come, because when we compare this particular aspect to the appointment of judges in the other aspects, whether even if we talk about the subordinate courts, it is supervised completely by the high courts. When we look into the appointment by high courts and Supreme Courts, it is done by the collegium, the primary says of the judiciary. But the appointment of the members and chairpersons of tribunals is something where the executive has a significant say. So the question on judicial independence is always there. And then with regards to functioning also, it is at times said that due to the procedural aspects or the detailed procedural aspects may be missing in some of the cases, it is likely to affect the overall functioning, etc. But personally, I think that, tribunals have actually worked, or the purpose for which the tribunals have been established in India, barring few exceptions, or barring few of the cases wherein the courts or the government itself has abolished or has done away with those tribunals, they have solved the purpose for which they have been established. One last particular and important aspect, which is not a very talked about topic, is something which is known as judicial impact assessment. So the Supreme Court of India, in the case of Salem Bar Association versus Union of India in 2006, has raised this particular issue and has given a suggestion that we must have a judicial impact assessment of all the laws and legislations passed in India. Something similar to the environment impact assessment, the EIA, that we have in India. So whenever a law is passed, which is to some extent going to impact or affect the environment in India, so an overall impact, or it is reviewed that what impact this legislation is going to bring on the environment. So the Supreme Court had suggested way back in 2006 that the practice which is very much in practice, or which is used in USA, the judicial impact assessment of all the legislations must be done in India. So that if a legislation is being brought, let's say this reforms ordinance is a legislation in 2021, which is going to have a direct impact on the functioning of the judiciary, and it is going to bring a major change in the organizational structure of the judicial setup or judicial system in India. So if a judicial impact assessment would have been done of this reform, maybe by a board or by a committee which consists of the members of judiciary as well as the members of the government. So they would have given their suggestions or results that, this is going to increase the burden on the high courts, or whether it is going to decrease, or what impact it is going to have on the overall justice delivery system or judicial functioning, etc. So this is a suggestion which the Supreme Court gave way back in 2006. That is a judicial impact assessment of the legislations in India, which I think has not been adopted till now. This is something which is very much necessary, and the Parliament should take this particular into consideration.
With this last question, sir, we have come to an end of this very fruitful and informative session. So thank you everybody, that all those people who have joined us today and heard us, and thank you so much, sir, for imparting your wisdom to us and your knowledge to us, and telling us all about the tribunals, their pros and cons and everything, and the significance foremost. And yeah, thank you so much for joining us.
Thank you for inviting and to speak about this particular topic.